On this week's episode of Off the Clock, we continue with part 2 of our discussion about non-compete agreements recorded live at the Miller-Johnson Employment Seminar.
Welcome to Off the Clock, the webcast of employment attorneys at Miller-Johnson, where we discuss what is happening in the HR world and provide practical insight and advice. So, and you mentioned something else that I just wanted to sort of follow up on, and that is we should be incentivizing people to stay, particularly our sales folks, by giving them what they want. Okay. How do we know what they want?
How do they know? How about we ask them? I am a big fan, huge fan of something called the stay interview. So we're all familiar with the exit interview when it's too late, right? It's too late, they've already moved on. Frankly, as Sarah and I were preparing for today, and we're all got our heads in it now, how do we get our people to stay? It's just we're using our imaginations, right? We're assuming a lot of things. Why don't we just ask people? And you can ask people in a stay interview whatever you like, but my favorite questions are, why do you stay? Why are you here? What do you, why do you continue to work here? And if you were to leave, which we hope you don't, but if you were to leave, what would the reason be? That's gold right there, right? And now you know. And it might be individual to a specific person.
Well, that's what I was going to say, right?
And now you know. And that person may be very important to you. And you want to know that information, or you may pick up themes, right? Themes, because our PTO is awful, because HR is mean, right? Whatever the theme is, and then you can make adjustments. But I just like asking people. Okay.
I would envision organizations even deciding to engage in that practice for their most valuable, with their most valuable people, right? Okay,
it's a great
Let's
strategy.
talk about the second bucket, which is relationships.
Relationships.
So when I think about relationships, what I mean are those external relationships. They can be customers, they can be vendors, they can be referral sources, right? Businesses use non-competes to protect those because we hire people and then we give them access to those relationships. And if the people we hire are really good, guess what? They're going to develop strong relationships with our customers, our vendors, our referral sources. And we don't want them to leave and take those people with them, take those relationships with them when they do. So outside of non-competes, outside of the easy button, what can we do there to protect those relationships?
We're going to give you the one that's probably on your mind, which is non-solicitation agreements. Get into those a little more deeply. But then we're also going to talk about, we're going to go off script a little bit and talk to you about what happens after someone leaves, right? Or actually when you're hiring someone too, actually cell phones, right? What do we do with cell phones? Because that's really where relationships are built, stored, right? All of that. So first let's talk about non-solicitation agreements.
Let's first explain what we mean by that.
Yes, it can mean a few things. The way we're using it here is after you leave, you may not, and the word is always solicit, although if you have a lawyer write it, it's going to have, right, a bunch of, so we look at the sources and come up with all of the different words we can use for that. It usually includes our customers, clients, whatever word, patients, right, whatever word you use in your industry. It usually includes our current employees, right, so you can't try to convince your whole group here to go after you leave. Right? And it can also include, from time to time, our prospective customers, right? And it says you cannot solicit these folks, these buckets of people, for a specific period of time. If it's just like a non-compete, if it's endless, it probably won't be enforced. In Michigan, right, 2 years is a nice standard, but you have to check your various states, because as Sarah showed you on the map, right, it's a, who knows, in the different states. But it's usually for a specific period of time, right?
Can I just back up?
There's all sorts of penalties if they do.
So maybe this is obvious, but when we talk about a non-compete, that's just a broad prohibition on them not being able to work somewhere. You can't work for our competitor or referral source within X number
Right.
of miles. When we're talking about a non-solicitation agreement, what we're telling everybody, what we're telling our employees is, you can work wherever you want. You can go work for our competitor, you just can't come after our customers.
Yeah.
So that's the difference.
Well, that is the difference. Well, I'm going to correct you. That should be the difference.
Yeah.
That should be the difference, because the FTC rule, at least, is very broad and says no matter how you characterize an agreement, if it has the effect of a non-compete, it's a non-compete and will be unenforceable, okay? So what are two ways a non-solicit can get pretty close to that line or cross it? So you think you've got an airtight non-solicit, right? But in fact, it might be non-enforceable because it's crossing the line of getting into non-compete world. One is the way it defines prospective customers. If prospective customers are defined so broadly that it's literally anyone who might be in the industry, right? You are essentially telling that person they can't work in your industry, right? In sales in particular, I'm picking on sales. Again, this is all very specific to your industry and the specific positions. I see some nods, so you know there's some situations, right? A paint salesman. If you say you can't solicit any of our current paint buyers and you can't solicit anyone who might ever be interested in purchasing paint at any time in their life, you're basically telling them they can't be a paint salesman anymore, right? For any competitor, and you can see how that could be interpreted as a non-compete.
Good point.
Right?
Yep. Absolutely, non-solicitation agreements are an excellent tool here in the stead of traditional non-compete agreements, okay? But they have to be thoughtful. The organization should first, involving not just all of you, but other executives, right? The top leaders in the organization, put their heads together to say, what is most important to us? What do we want to make sure people cannot take on their way out the door in terms of relationships, and then write the non-solicit narrowly for those things.
Further,
Don't throw a bunch of paint on the wall and say, oh
Right.
good, we're going to call it a non-solicit. That's not going to serve the purpose here at all.
further to that, the second area where non-solicits can cross over into the world of non-compete is when we define what it means to solicit too broadly. I've seen non-solicit agreements where I, in fact, have made the argument on behalf of a client that it's actually a non-compete because it's called a non-solicit, but it says no matter who you work for, you can go work for a competitor if you want, but while you're there, you may not do the following activities. And they're written so broadly that it essentially means the person can't do the job, right? If they were hired to do a similar job for a competitor for which they work for you, they essentially can't do it, which means essentially it's a non-compete, right? So to your point, right, we do have to be thoughtful and not really to self-promote, because I think you all already know this already, but this is an area where lawyers need to get involved, frankly, in making sure they're written nice and tight and protecting just what you really need to protect.
Okay. Now, I want to talk about something that Rebecca knows is really close to my heart and I love talking about, and that is cell phones. Okay. I see a lot of businesses who are very, very intentional about non-competes, even non-solicitation agreements. They make people sign the paper promising that they are not going to take confidential information with them, they're not going to solicit their customers, they're not going to work for a competitor, et cetera. And then
It's a bring your own device rule.
it's a bring your own phone to work,
Yeah.
which gives your top salesperson the ability to take all of your customer information with them, not only when they're employed, but when they walk out your door.
And it's not just customer information, by the way. This bleeds into the next section about protecting your information. I'm looking down, I put my cell phone over there because I wouldn't be distracted because I'm so addicted. But our cell phones, think of all the attachments to emails. I mean, it's not just the customer list and phone numbers.
Yeah.
I mean, the price lists are in there, the proposals are in there, the business strategy, right? Because we're all emailing this stuff around and then we have them on our phone, and I don't know about your phones, but I have all sorts of business apps, right? I have a PDF app. I have a place where I have document storage app.
Right.
So what's the solution, Sarah? Just scared everyone.
The solution is this.
Let's give
Again,
them the solution.
if this is a person for whom it would be important for us to have them sign a non-compete or even a non-solicitation agreement, a person who's going to have access to our most important relationships, they should be using only a company phone for work, and we should own that phone. And most importantly, we should have the ability to wipe that phone clean whenever we want, but definitely when the employment relationship ends.
This is an investment. I know some people think the concept of having two cell phones is odd, right? A work phone and a personal phone. In some work cultures here, I mean, some companies it's common and some it's not. So for some of you, you might be like, well, why would someone they literally carry two phones around with them? Yes, there are people that literally, we are friends with some, that literally carry two phones around with them. This is, if you're not gonna have non-competes and you have sales folks and non-competes are important to you, this is a very good investment, right? This is, I can't really say it enough. Now, the question that I get when I talk to clients about this is, well, what if the person's cheap? Right? We buy them a phone, we say this is only for work use, et cetera, but then they use it for personal stuff, and they do take pictures of their kids on it, and they have their vacation pictures on it. Can we really wipe it or insist that they just hand it back over? I see nods, yeah, especially
Absolutely.
I would highly recommend you having a good policy first that says that you can. I would recommend that being a standalone policy. With any policy you actually want people to understand and read, right? Yes. That's their risk. That's on them at that point. But we do have some invasion of privacy issues, et cetera. So it is important to put people on notice that if you use this phone for personal stuff, guess what? We have access to it and we can wipe it and you can lose it all. So we highly recommend you have a second personal phone.
Yep. Lastly, thinking about these relationships, the same principles that we talked about with regard to our own employees obviously would apply to them too. Rebecca talked about layering, having an organizational priority to have multiple touches between our most important customers and the organization, not having that be a priority in figuring out a way to incentivize that as well. How do we incentivize our sales folks to layer with our top 50 customers, our top 20 customers, right? We can tell them they're supposed to do it, but how do we make sure it happens?
Mm-hmm.
Tie it to compensation. It's all about compensation, right? Some element of their compensation could be tied to introducing other employees, other sales folks to important customers, for example, in developing those relationships. And then, of course, regular engagement with our customers, our vendors, our referral sources about what we're doing well and what we could do better, right?
Yep.
That's 101.
All right, let's move on to information. How do you protect your information? And I'm using information very broadly, right? It could apply to a whole bunch of things, including not just documents with price lists and customer lists. It can refer to processes, for instance, how you, because of your human, the people that work for you are brilliant, and they've come up with a way to do something faster or with higher quality, right? Those types of things, processes, those sorts of things can be the information we're talking about too. Really, it's anything that makes you better than your competitor. That's really how I want you to think about this, and I want you to have, now I'm being a little bossy, and I'm sorry. I suggest that you have conversations with your C-suite leaders about what makes us better. Whatever we do, why are we doing it better than our competitors? This, by the way, can have lots of spin-off conversations, right? That can lead to lots of other great ideas that are beyond the topic of this breakout session. Those are the things I'm talking about that you want to protect, right? And you've been using your non-competes to do that. First of all, before we get to some fun lawyer stuff, let's just talk practical. And we're going to scoot through this because we're just a couple of lawyers, as we tell each other that all the time. And this is really an IT solution, but we've seen it with our clients. There are technical tools to lock things down. So for instance, certain documents or information can only be viewed in your environment. So if it is taken, it's encrypted or something like that, right? It just doesn't work outside of your environment. There's ways to make certain types of documents unforwardable, right, or uncopyable, et cetera, et cetera. Make sure that in your document management system, to the extent you have one, that things are filed in a way and stored in a way that only people with a reason to know have access to those categories of documents, okay? So that's all tech stuff that I'm not going to get into deeper because I can't. I just know it exists. I leave the rest up to you and your consultants. All right, so let's now talk about the fun legal stuff. First of all, probably what you all came in here already thinking, so I'm going to talk about it, are confidentiality agreements, right? Sometimes these are combined with the non-solicit, right? So it'll say non-solicitation and confidentiality agreement, or they can be standalone. Sometimes they're called non-disclosure agreements, NDAs. It's all the same thing to me, right? One question we got ahead of time, which we really appreciated, was should we put these in our handbooks? There's nothing wrong with putting it in your handbook. It could still be enforceable. But if we think about the purpose of these types of agreements, there's really two. One is deterrence, and one is can we enforce it after the fact when we need to, which hopefully you won't if you've deterred, right? You really don't want to go after damages after, right, your recipe for Coke gets stolen by Pepsi. You want to prevent it from being stolen in the first place, right? How many of your employees read your handbooks cover to cover?
Wait, other than the PTO to find out how much paid time off, how many
of you have read your handbooks cover to cover? Okay.
All right, applause for
yes,
you guys.
Of course. We don't have a poll. We don't need it. Right? We read them because we do them for you. We may be the only ones. All right. So with an agreement, a non-solicit and a confidentiality agreement, whether they be separate or together, that I don't have a strong feeling about, frankly. You want it standalone because you want the person, first of all, to read it. You still can't, I can't promise you they're going to read it before signing it, but they'll know they signed it. Or, let me put it another way, they're more likely to know they signed it. Again, I can't make any promises, but it's more likely to serve the deterrent effect you're trying to achieve. Secondly, we recommend, and I know there's going to be a lot of groans in the audience, I'm sorry, HR folks, but if you can have people re-sign these things on some sort of routine basis, that would be great. And I know I'm getting the dirty looks now, even through the blinding lights. One more thing for me to have to keep track of. Again, this is just the buffet, right? These are all the options. You can take what works for you. It may depend on maybe just certain individuals.
Right.
Maybe
So
your
why,
key salespeople
what are we
resign
trying,
every year.
Rebecca, by having people re-sign these things, which is a lot of work for the folks in this room, right? What are we trying to accomplish? Why are we having, what message are we trying to send them? Why are we doing that?
Well, first of all, we want them to know we take it seriously, right? The second point, it really comes from that, is that culture, the culture of what is confidential and that this is actually very important to us. How many things do you have your employees resign every year, right? So if your sales folks are doing that and then they're thinking of back to where we started, and then they're thinking of going, and they know they have things that would help them in their new position, get higher commissions, right? And what they're thinking is, because we get these calls, I'm telling you, we work all sides of non-compete issues. By the way, we're normally only management. We work all sides of this. The number one question we get from that person or their new employer is, do you think the other one's going to enforce it? Mm-hmm. Do they really care? That's the number one question. Do you think they'll really enforce it? Right? Because everything's a risk decision, a business risk decision, right? And if that salesperson says, they had me sit down and read it, someone was watching me read it and re-sign it every year, I think this is really important to them. I think, you know, if they're thinking that, they may be less likely to leave in the first place.
That makes sense.
And so that, deterrence, deterrence, deterrence.
Right. That, I just want to say, that makes me think of HIPAA in healthcare.
Yeah.
Okay, 10 years ago, there was a general idea that patient confidentiality, et cetera, is something to be thinking about, to be concerned about. We're not supposed to disclose it. There is no question that healthcare organizations have created the culture you're talking about
Oh, yeah.
for health protected information. We can look at what they've done and how they've done that and how they've set that culture for their employees, and use that as, in my opinion, as instruction as to how to accomplish the culture you're describing. And the confidentiality agreements, to your point, great tool. Just so everyone in the audience knows, they don't have to have an end.
Yes.
They can last forever.
Unlike non-solicits.
So we're much less handcuffed when it comes
Yep.
to confidentiality agreements. We just need people to know they signed it and that we take it seriously,
Right.
quite frankly. So
You can be very broad in your confidentiality agreement.
let's end on a high note.
Oh, should we?
Yeah.
Okay. People that have heard me speak before know that I love to end on a high note because I feel like it's been a little bit of a downer. Nate with his NLRB stuff and now me with the end of non-competes. But let's think about how we can turn this into an advantage for you, but how to do it smartly, okay? In a world without non-competes, it's like one of those movies.
Yeah.
I can't
Imagine a world
Imagine a
without
world
non-compete.
without non-competes. You all now can hire the talent from your competitors that were off limits.
So this goes both ways.
Wait a second. Instead of us saying people are going to come raid our people, well, hold on a second. Right? It's only fair that we can do the same. So you and your leaders can start opening your minds and thinking about, in 2024, without non-competes, we're not going to have them. That's a bummer. But our competitor's not going to have them either. What kind of talent can we add here, okay? This is frankly the time to start having those conversations. We don't know for sure, right? And who knows in the different states that Sarah showed you, maybe they're already not enforceable. Maybe you can already go find talent in those states, okay? So I think that's pretty exciting from a recruiting and a business growth perspective that frankly is not in any of the blogs or articles about this, but that's one upside. And we're going to talk about how to do that smartly though, so you don't get into hot water, particularly if there are still some non-solicits or non-competes hanging out there, okay? When you're in the recruiting process, always ask what type of restrictive covenants they have with their current employer, right? I see nods. Hopefully you're already doing that.
And I just want to emphasize when you're in the recruiting process. There's nothing worse than hiring a talented executive or salesperson because of the relationships they're bringing with them, and you find out a week after hire that they actually have a non-solicit agreement,
Right.
so they're not of nearly as much value as you thought they were.
Right. So you want to know what you're getting into, right? And if this is a good hire, if this is a valuable hire for you. If you move forward, in whatever employment agreement you use, offer letter, employment agreement, I don't care what form or title it takes, it is very, very helpful to you, the organization, to have them acknowledge that they do not have any restrictive covenant that prohibits them from working for you. And assuming they have a confidentiality agreement, which I'm sure they have, right? And most will also have non-solicits, particularly in sales, that they will respect the restrictive covenants, right, with their prior employer, particularly with confidential information, because there's a concept of trade secrets, right? Confidential information can amount to a trade secret. The trade secret law, the Uniform Trade Secret Act, makes you potentially liable for using information that was taken unlawfully, even if you're not the person who took it. So how do we show you didn't know, you had no intent, blah, blah, blah? Well, we said right here, right? We're making this person promise that they're not gonna do this. And then if you have a rogue employee or new employee that comes with the flash drive, right, that you had no idea and you find out 2 months, these things happen because we work on these cases, you've got a good defense for the company, right? That you didn't know, you didn't want it, right? You were not complicit in that.
Excellent, excellent.
And then also one last point in high-risk situations, and we all know what those are, right? In very, very high risk, it's a key player for your competitor. You really think they might come after you. You really think a lot of the employment agreements, comp systems, et cetera, might be subject to discovery, either in litigation or in arbitration, meaning everyone's going to see everything and pick it apart. think about your compensation system, particularly for sales folks, and whether it's set up in a way to incentivize or disincentivize them for breaching their covenants with their previous employer. Because otherwise, everyone's gonna be like, okay, fine, some lawyer inserted some great language in your offer letter, well done, but you all know this person can't make a dime, right, unless they breach, the way the comp structure is set up, they can't make a dime unless they breach their covenants, right? So think about that in high-risk situations.
Excellent. Thank you.
Thank you all. That's all we have for you, and our time is up. This was so fun to do
Thank
it
you
live.
guys for joining us.
Thank you.
It's much more fun with an audience.
It is. Also
Thank
a
you,
little
guys.
more nerve-wracking.
Yeah.